Hey everyone, thank you so much for joining us. It's just after 1 o'clock. I can see that we're being joined now by Daniel Senior, who's going to be our guest speaker today. And to all of our participants that have joined online and the many that came a few minutes early, thank you guys for your patience today. And thank you to Dave, who delighted us with that music. We had planned to put on the theme song from Law and Order, but copyright protected or so I'm told. So we are here to talk today about wills and estates. Dan, can you hear us okay? I think you might still be muted.
I can hear you fine.
Oh, wonderful. Okay, great. I can hear you too. So thank you so much for joining us. So we are here today, of course, to talk about wills and estates. And everyone, I just want to do a quick intro. Some of you know me, some of you don't. My name is Carol Foderick from the Carol Foderick Real Estate Group here at Keller Williams. And I'd like to welcome you this afternoon to our most recent educational seminar in our ongoing series designed to educate and empower you guys, our clients, or people that we may have the opportunity to serve in the future if we haven't already. Today's topic is going to be all things related to wills and estate planning. Probably not the most compelling topic on a beautiful summer day, but definitely something that you want to turn your mind to. So we're going to be talking about everything you need to know with regards to wills and power of attorneys, or at least as much as we can jam pack sort of into the next hour or so. I'm joined this afternoon by Daniel Senior of Think Green Law. He's one of our preferred vendors for our clients needing a referral for legal services, not just wills and powers of attorney. Dan also practices other points of law, and he'll talk about that shortly. And he is going to talk to us today about what you need to know to have your legal affairs in order, or perhaps legal affairs of somebody that's close to, whether it's a parent, a child, a sibling, why that's also important. For some of you here this afternoon, you've joined because getting a will or power of attorney has been on your to-do list for a really long time, but you've just never gotten around to it. For some of you, maybe you've had a version done, but you've had life changes and you know it's time to update. Or perhaps you've been asked to be an executor or a power of attorney for someone you care about, and you want to know what exactly that means to you and what your obligations are going to be. We are going to unpack all of this today. And of course, there's always going to be an opportunity for questions at the end of this. I'm joined today by just my exceptional sales team, the agents that invited you to this meeting today: Caitlin, Amanda, Katisha, Sarah, Matt, Dushan, Manuela, Gabriella, Leah, Emily Salter, Emily McIntyre, Alessia, Devin, Sylvia, Kelly, Carolyn, Scott, Blair, and Lydia. My goodness, we sure have grown in the last year. But as realtors, why do we host seminars like this? They're obviously not directly related to real estate. It's because our approach to being part of your financial services team. So we really want to try to be part of your trusted advisory circle based on this fundamental team vision that we have, that it's our job to provide you with the information and resources that you need to make good fact-based decisions in all aspects of your financial life. So not just real estate, not just law, but hopefully everything. It's our hope that you find this seminar as a reflection of the high level of professionalism, the integrity, and the service that we strive to provide to each and every one of our clients, either before, during, or long after the privilege we've had the privilege of completing a transaction with you, a real estate transaction. If there's somebody that you know that has a need for this information, please feel free to share this after the fact. And of course, your agent is going to be reaching out to you to see if you have any follow-up. There is just so much to unpack with what's going on, not only with today's topic, but also the real estate market. So if there's anything we can do to be of service to you, just please reach out anytime. A couple of housekeeping notes. Today's call is going to be recorded for the benefit of the people that have registered, but were not able to attend live today. So I'll ask you to keep your microphones muted just to eliminate any background noise. And finally, if you'd like to ask a question or you need clarification on a particular point, please do it using the chat function. We're going to have a question and answer period at the end of the call, at which time the floor will be open to all of you to ask your questions. I know many of you submitted questions in advance, which we're going to go through as well. If you have a question that you'd like to have asked anonymously on your behalf, you can use the chat function and send it to me privately, and I will make sure that it gets asked. We're also going to be sharing this recording with you tomorrow, so expect to see that link sent out so you can review any of the information that we shared here today. And of course, the best part, Dan has very graciously agreed to give away a wills and estate package valued at $1,500 to one of the lucky participants on this call. So towards the end of this call, we're going to be drawing for somebody to have their legal expenses on their will and power of attorney covered, which is just a very generous gift. So thank you so much, Dan. And without further ado, I turn it over to you, Dan. Clearly, I've had a lot of caffeine today, but I'm going to turn it over to you, Dan.
Yeah. Thanks so much, Carol, and thanks for having me back. We did this, I think, as you mentioned there, we did this last year as well, and there was a lot of really positive feedback, and more importantly, I think it goes a long way to help people where this is a relatively simple topic, but it can feel overwhelming and confusing for people when you're not in the industry, you haven't spent time researching, or you're just not in the know. So being able to help and offer some of this advice. Today it'll be a little bit more truncated than than going through the whole legal world of wills and estates. Obviously, it's very complicated when you get into the nitty gritty of it. But we'll touch on the main items and then again, go through some questions and hopefully that can give everyone a little bit of a background and a starting point to get more involved and make sure that your estate is taken care of the way that you'd like to do. So I'm going to go ahead and share my screen, and we've got a presentation here that will be helpful for that purpose, and we'll kind of go through it, and then as we go along, we can chat, and again, any questions, we can do that at the end, and Carol, you're welcome to kind of have some
Amazing.
feedback.
Yeah. Well, you're getting that set up, Dan. I'll just say that, it's been my experience when I'm talking to clients, because a huge amount of the work that we do as real estate professionals actually involves estates. It's a specialization that we have on this team. So whether it's somebody that is dealing with a family member's estate and they've passed away and we have the real estate to sell on the estate's behalf, or it's a power of attorney situation where we're working alongside, say, adult children who are having to make decisions for an incapacitated parent, it's something that we do quite a lot of. And I will say, Dan, it seems to me that there's a lot of misinformation that floats around regarding wills and estates, because we are so heavily influenced by either the United States or information that's shared through social media or the internet in the US, or even from other provinces. And I think it's really important that everybody's here to educate themselves about what the law is in Ontario versus stuff you might be picking up or stuff that's been shared with you in the past that's actually not even relevant to an Ontario legal transaction.
Correct. And I'm actually having my screen and your screen aren't communicating very well right now, so we're having a little bit of a technical snafu, but we should be good right now. So we'll go into it and we'll kind of go through
Amazing.
yeah. All right. So we should be able to. I'm going to go ahead and share my screen if we can make sure that works.
The miracles of technology, right? Dan, this was supposed to be so much easier when we could all connect electronically. We used to do our seminars in person right up to the beginning of the pandemic, and we'd have everybody come into like a room and I'd serve pizza to everybody. But this is great because you can share a screen and you can see all of the information that we're looking at together.
Right. And so here, hopefully we can.
Yeah, we're good. I can see you. You're not in presenter mode, but go ahead and you can start talking through this, I think.
There we go. Can you see my screen now?
I can see your screen now. It's
All
very
right.
easy.
Okay, here we go. Yeah. So, okay. So we'll kind of start and go through the main items here, and we'll give a little bit of background on our firm and what we do, and then we'll again at the end we'll do some questions and answers. So, a little background on our firm. Carol, you already introduced us. Our firm specializes in real estate, corporate, and wealth planning. We also do some business consulting and advisory services, helping business owners buy and sell businesses, identify potential targets to acquire if you're looking to expand, and identify options for selling or borrowing and soliciting investment. As a law firm, our core it really is real estate, corporate, and the wealth planning aspect. And from the wealth planning aspect, we're going to touch on some of the simpler stuff today, but we do a lot of more complicated things, especially in the commercial context for some of our corporate clients, with things like estate freezes and reorganizations and rollovers and all sorts of fancy things that you may hear from time to time when you're looking at TikTok or something like that, family trusts, all of those kind of things. For today's purposes, we'll kind of keep it a little bit more tertiary and simplified. So our agenda for today, what we're going to talk about, the standard concepts, wills, powers of attorney. Then we're going to talk a little bit about probating. So that's after you've passed away or someone's passed away, what the process is there, what it looks like, and how you can minimize, we call it probate. So your probate fees, your estate taxes. Those are kind of the two words, the vernacular that you'll hear there. And then we'll come to, because this is probably what everyone has on your mind coming to this presentation is, well, how do I create a will? How much is it going to cost me? Do I need to hire a lawyer? Can I do it online? Can I do it myself? Those kind of things. So we'll try to simplify it for you a little bit. And just to make sure this is working right now, it seems to be for me. Carol, you can see here, what is a will as a slide?
I can, yeah.
Perfect. All right.
I don't think you're in presenter mode though, but this is fine. Everybody can see it. So I think let's just move forward with this.
Okay, is it clear and it's working okay?
I think so. Yeah, for sure. Anybody who's watching on a device should be able to read it.
Okay, great. Okay, so basically, when we talk about a will is a written document that gives your directions for what you want done with your estate, so your assets after you pass away. But it's not just your assets, it's your house, your investments, all of those kind of things. It's also you can give some additional context to the people that are dealing with your estate after you pass away. For example, parents of minor children, you can give instructions as to who you would potentially like to see acting as the guardian for your children. And a will really gives you control to tell people after you're not there anymore what you want done with your stuff and the people around you. So it allows you to appoint who's going to be the estate trustee, the person who deals with your estate on your behalf. It allows you to name the beneficiaries. It allows you to say what those beneficiaries are going to be receiving in terms of property and the breakdown and how you exactly want it to occur. And again, it also allows you to provide for some context in terms of guardianship for children. And that's a really big one for people that have minor children. Important to know, a will doesn't take effect until you've passed away. So while you're alive, it's revocable. You can change it. You can change it two ways. One, you can do a new will, or two, you can do what's called a codicil. We'll come back to that in a little bit. And it doesn't become binding on you until you've passed away. The important context and the thing that everyone is kind of here and needs to know is there's some very specific law around wills. The context of formalities and making sure that your will complies with legal requirements is exceptionally important. The law has been changed a little bit recently to soften and round the edges to allow for small exceptions to irregularities in wills that were attempted to be drafted, but there's some errors in it. But still, it's very critical that your will is accurate and follows all of the rules. Wills that aren't and don't follow the rules can be tossed aside, and you can end up in a situation where even though you thought you did a will, you didn't do it right, and the courts say you don't have a will, and so again, you lose control of all of those kind of things. There's also concept that you may hear of or read about on the internet of holographic wills. We're not going to go into detail on those today. Those are essentially they're not a standard type of a will, but scenarios in which you're, say, in an accident and you immediately, just before your death, write down some of the things that you want can also be considered in the context of your estate. It's complicated. We're not going to go into that. They're very tricky, and you should avoid that at all costs, because that requires, on your deathbed, you writing something down. Also important, and we'll talk about this a little bit, is the context of just because you have a will doesn't mean that will governs no matter what with respect to your estate. There are other legal requirements that have to also be fulfilled. And so even if you have a will, there are still estates are subject to things like dependency claims. If you have minor children, then they are entitled, even if you leave them out of your will, they're entitled to support in most or certain contexts, spouses, and in some contexts, former spouses, if you haven't had had a divorce or a separation agreement that specifies that a former spouse, even though you haven't been together for a year, 2, 5, 10, 20 years, may still have claims against your estate. Why should you have a will? Okay, so we just alluded to it and talked about it very briefly. The main one is it gives you control. Your will and getting a will done is an investment for you for the control of your estate after you pass away. So it ensures your assets are distributed the way that you desire, and it allows you to give the trustee, the person who you trust, that's going to be acting for your estate after you pass away, certain powers to do certain things, pay your bills, pay your taxes after you pass away, which you have to do. Even though you're in Canada, even though you've died, you still have to pay your taxes, and pass money down to your beneficiaries and all the things that you want to happen. If you die without a will, there's a term for that that's called being intestate. So you don't have a testamentary document. And in that case, where you don't have a will, proper testamentary documentation, the applicable laws that that the courts will apply and legislation applies, they determine what's going to happen to your estate. So if you die and you've got a property and a bunch of money and you don't say who and where it's going to, then someone, generally a judge, will make decisions for those things without your knowledge or input. Now, the laws don't always, and we just talked about this a little bit, don't always reflect your wishes. There are certain things that can happen that you need to take into consideration, and that's where it can be really difficult if, and we'll come back to this later, the concept of doing your own will, trying to do it online, trying to just do it based on something that you see on a website. Those things they're really fraught with difficulty, especially in the context of we have Canadian and Ontario specific law, and you may be seeing things online that are American, or Alberta, or BC, things that don't necessarily apply to Ontario. Things to keep in mind that you might not be aware of when you're trying to do it on your own. The distribution of your estate may not be, and this is in the case of where you don't have a will, may not be in the way that you choose. So I've given a little example you'll read there. So in the case where you have a favorite child and you don't like your other children, you on your death can leave more to one child than the other. That's not necessarily the case if they're minor children, but importantly with a will, that lets you leave money and assets where you want them to. If you're estranged
Daniel,
from a
just interrupt
spouse,
for just a minute because I have this, and I think it's important to understand there are reasons that people may choose to change distribution in a will temporarily or for a set period of time. Say, for example, you've got a child who's going through an adult child who's going through a divorce, and you don't, should you have an untimely death, you don't want assets to pass to, what will soon be your ex daughter-in-law or your ex son-in-law. So I've seen that quite a bit. I also just want to perhaps touch on something that is going to be relevant to a lot of the people on this call. I know it's, relevant to me, why it's important to have a will, not only for yourself, but to look around sort of your immediate family or sometime an extended friend circle.
Yes.
And identify.
At the bottom of that email,
I'm sorry, Amanda?
there's a little.
Oh, sorry, Amanda's just logged on, and I'm just going to mute her. Dan, I just wanted you to speak if you to the people here who may have an immediate family member, whether it's a parent, an adult sibling, who don't have a will. In lieu of having a will, how much more complicated it makes, because of course the person who passes away without a will is not charged with sorting out the legal mess that can come from not having a will. It falls to somebody close to them, usually a sibling, a parent, a family member. And this is something that you and I have navigated because, as you know, my husband has had to step up to be trustee of an estate for somebody who passed without a will. And it has been a legal nightmare that has been incredibly expensive and incredibly time consuming and a lengthy process. So maybe you can speak not only why the person listening to this call should have a will, but why you may need to identify other people in your life and encourage them to get a will if it's likely going to be you that has to sort it all out on their passing anyways.
Yeah, and that's a good point, and we'll come back to it, and I won't touch on the specific circumstances, but yes, we've got we're working together to help alleviate some of the issues there. But wills, to do a will properly, to hire a lawyer, and there are different ways of doing it. We'll come back to that later, kind of near the end of the presentation, but it can be a little bit of, if finances are tight, then investing now and spending money now for something that in your mind, and we commonly think in our minds, I can deal with this later. I'll deal with it in a month. I'll deal with the will in 2 years, in 10 years. I'm young. Nothing's going to come up. We never know when the end is coming. And so planning in advance really is an investment in not only your ability to control what you want to happen afterwards, but an investment in and to potentially save fees, save costs, and leave more to the people in your life, your loved ones and your close ones, but also to help them, help alleviate stress and cost on your loved ones after you've passed away, and allow them the opportunity to grieve and to celebrate you and your life, as opposed to having to just jump full bore into what can be complicated and isn't inevitably very much more expensive, where there's no will and no organization to a person's estate. It really adds a lot of cost. So there are, and we do see it quite frequently, where someone may be single, may not have a lot of money, a lot of assets, a lot of income. So for them personally, spending some money to go and get a will done is a very difficult proposition. Funds are really tight, and doing that is quite a difficult proposition. But we do have a lot of clients where their parents or their other family members, people that are going to be the ones tasked with helping their estate after they pass away, paying some of those fees because they know it's an investment to themselves as well. And so, like you say, Carol, it's not just incumbent upon the person themselves necessarily to ensure that they have proper testamentary planning and they've paid to have a will done, but also the people in their life. So the people in your life that you may have to be doing this for or helping with, it can be an investment for you, so that you down the road are much more easily able to deal with these things. And it allows you to work with that person while they're alive to help get them organized and help you after the fact. And again, it's that concept of, we can always do this down the road. At some point down the road is now. So it really is important to invest time and attention in this now and as soon as you can, so that you don't have that lingering over you down the road. Back to what other reasons you should have a will, not just as you mentioned there, Carol, the stress and cost that accumulates for people who don't have wills, even those that don't have a significant estate, but also it allows you to do things like donate to charity that wouldn't happen if that's what you want to do. That wouldn't happen under the intestacy rules. If you have disabled family members, there are certain tricks and things that we can do with wills that allow you to provide for people with disabilities in your life, children with disabilities, whether it's physical, mental, someone with autism or something like that, that allow you to still leave assets to those disabled family members or loved ones, but still allocate them in ways that allow them to maximize government help as well. So especially for people with disabled loved ones, it's very, very important to do these in advance, because there's a huge potential benefit for them, as there is for everyone, but in that circumstance particularly. Now, another very important note is, if you are separated from a spouse, if you were married and you're separated now, it's very important for you to A, get a divorce if you were married, and B, or to get a separation agreement. In the case that you don't have those, it can really affect and prejudice your estate, because the law presumes that spouses, even estranged spouses, potentially have claims against your estate. So we're not going to go into the details of that, because that becomes a very complicated family law and estate combination of an issue. But it is really important that you speak to someone knowledgeable in the field. That's where, those kind of complicated things are really important to speak to a lawyer, because if you don't deal with it now, then it really could have a prejudicial effect on your intentions. One of the concepts that you'll see when you're looking online and you're hearing about wills are can I do multiple types of wills where I put some assets here and some assets there? And the answer is yes. And to simplify, generally speaking, in Ontario, we have a concept of primary and secondary wills. Most people on this call, and just most people generally, only need one will. One will deals with everything in your estate and all your testamentary wishes. People who own businesses, though, and have certain types of land assets, there's certain types of assets can qualify to be left out of your primary will and put into what we call a secondary will, or we also call them often a corporate will. From the property perspective, we won't go into detail there because generally it's if you've owned property for a long period of time. And the exceptions deal with that. From the corporate perspective, what this really allows you to do, so if you own a small business, this is the part of the presentation to listen to and pay attention to. If you have a business, you're able to have two wills. The second will deals with your corporate assets. What that allows you to do is your primary will, when you pass away, goes through probate and the courts deal with it, and you pay probate tax based on the value in the primary will of those assets. Your corporate assets stay outside of probate for tax purposes, and you save essentially 1.5%, which is about the probate fee on your assets after you die. You're able to avoid that percentage entirely on those corporate assets if you've utilized the secondary will. So it can be very, very advantageous if your estate is only, if your estate's only going to be $100,000, there's not a lot of savings. But for people who have businesses worth $1 million, $2 million, $5 million, they can really see some savings there. Now we get into, you've got a will. What do I do if I want to change my will? Well, there's two things. You can either prepare a new will and get rid of the old will. To get rid of the old will, you destroy it. And that's the primary mechanism for that. You can also do something called a codicil, which changes certain little things in wills. I don't recommend that you use codicils, which are, a little amendment to your will, for big changes, but for little things, small changes to remove a gift, to change a charity, for things like that. If a loved one's passed away that was going to be a beneficiary, to remove them, things like that, they can be quite helpful. Oftentimes, though, wills aren't, generally speaking, all that expensive to do. So oftentimes it makes more sense to do a new will.
A question for you, Dan, just on that, if I can interject, is from the pre-submitted questions, or was one that was specific to this. And it asks, and it's a question from Sylvia, if I make specific changes to my will after it has been drafted, nothing major, just maybe specifics about which pieces of jewelry, things like that to specific people, do I have to have those changes notarized, or can I simply add the changes in writing with my signature and date? So again, no major changes. It's just like, hey, I want my heirloom rocking chair in the living room to go to my nephew. Is that something that needs to be notarized, or can it be made? Can you make changes in handwriting to your will and have them legally recognized?
So technically, without going into the whole balance of formalities of wills, you can do that. You can make changes. Nothing needs to be notarized, technically. But there are formalities in terms of witnessing, signatures, dates, all of those kind of things. So when you do a will, for example, you have to have two witnesses. They have to be there together, watching you as your witness when you sign it, and they see each other sign it. So your witnesses have to be present at the time that you sign the will, and everyone signs. We always have everyone initial each page of the will. That way, both the testamentary and the witnesses all have verified, not only have we seen each other execute this will, we've seen each other execute each page. And then after the fact, when we go to apply to the court for probate, we're able to know, confirmed, this is the exact page with the exact language in that format. And no one slipped something in to make a little bit of a change. So that's really important. In terms of changes like this, where this question goes, is you can do that kind of thing, and that's exactly where codicils come into play. As long as you've done it properly and there's the correct signatures and witnessing, then that's okay to do it that way. I wouldn't suggest that you take your will, your original will, and change something on it and then just sign and date it. Again, I would do it on a separate document saying I am amending, and there's certain language that we do, and is basically saying I'm amending my will for the following, boom, and then you're signing and have it witnessed as well is very important. That way you're able to, after the fact, your estate trustee is able to verify this document changed the original document and it was verified and witnessed. So that way the court can rely upon it. Yeah. Other questions about what to do after your will, not just about changing your will, but what do I do with it? I've got a will, I've got a piece of paper. How do I know that this is going to end up in the right hands and not go missing? Because that happens all the time. And Carol, we've got mutual clients and friends where we've seen that in particular as well. A will goes missing. Does it exist? There's a photocopy of it or a scanned copy of it. Does that count? So sometimes, and then it becomes, again, very costly, and the people who have your loved ones who have to deal with it after the fact have to go to the court and explain, this is what we believe is a copy and this is why we believe you can rely upon it, and we don't know where the original is and we don't believe it was destroyed, we just can't locate it. So it creates a lot more complexity. So what we usually recommend, especially if you're utilizing a lawyer to help you, but secure your will in a place that's safe. So waterproof, fireproof safes are very helpful. You want your estate trustee, whoever's going to be acting for the estate, to know where the will is, so that when you pass away, they know they can go to this place, whether it's a bank safety deposit box or your lawyer's office, and go retrieve that will and have copies of it. One of the things that we do as a service for our clients is we offer for clients to leave their will with us in a waterproof, fireproof safe, so that when they pass away, and we give them a copy of their will, of course, they're able to give a copy of their will to their estate trustee and say, if and when I die, call Dan, and his office is going to help you. They've got the original and they'll help you, and we've already done this. It's organized and they're ready to go to help make things easier and less stressful for you while you're grieving and celebrating my life. Going further, when we do wills, we also generally in Ontario, we talk about doing your will, which is the document after you've passed away, but also what happens while you're still alive, but you may not have capacity to make decisions for yourself. So you're in a car accident and you become incapacitated if you're in a coma, or dementia sets in and you aren't able to make decisions. Well, that's where powers of attorney come in. So the concept of I'm still alive, but I can't make decisions for myself. In that case, you can't make a will because you can't make decisions for yourself, and you're not able to express on your behalf, I want this type of medical treatment. I want my investments dealt with this way. I want to make sure that now that I may not be able to make decisions for myself, but I'm still alive. Maybe I have some brain trauma or something like that. I still want to be taken care of with my hard-earned money. I want my house sold or my investment sold and used to make myself comfortable in an assisted care facility, things like that. Those allow you to, power of attorney is a document that allows you to express those wishes, and it allows you to provide a trustee, someone you trust, to act on your behalf. So we, generally speaking, will do those documents at the same time we do a will for clients to make sure that we've got them covered after they pass away, and if they're incapacitated during life, so those decisions for their property and their personal care are taken care of. In Ontario, very importantly, we really break it down into two concepts from powers of attorney, and that's one is your personal care and the other is your property. The reason that we break it down into two separate documents is because there's a slightly different test legally for your capacity to make decisions for property-related issues and for personal care-related issues. The test is, do I have capacity to make complicated investments and portfolio strategizing and things like that, is a little bit different than, do I have capacity to say yes to this or no to that, maybe a blood transfusion, or go to this care facility versus that one. And that test is a little bit different. So we do two of the documents to deal with that.
Can I ask a question about this, Dan? Because this is something that's come up in our business with a client very recently, and I think it's something that needs to be highlighted to understand the necessity of having a power of attorney. I have a client currently, and it's an elderly couple. The wife, unfortunately, is suffering with severe dementia. She is past the point of recognition. If anybody's ever lived with somebody that has issues with Alzheimer's or dementia, you'll know that there's sort of a critical point where they no longer have awareness. And they no longer have capacity. So I was approached by the husband to say that it's time for them to, sell the condo and move into a care facility. Unfortunately, there is no power of attorney in place, and now I cannot establish capacity that the wife agrees to this, and he has no document to say he has legal authority to act on his behalf. So really, I really want to underscore this. The complexities of what can happen with unforeseen medical situations can be very, very dramatic. This could end up, they may not be able to transact this condo and certainly not anytime in the foreseeable future. Incredibly expensive legal process now to sort this out, because we need to be able to establish that either the husband has legal authority to be able to transact on the wife's behalf, or the wife has capacity to sign on her own behalf. And unfortunately, neither of those things can happen. So super important, guys, that everybody understand the necessity. I hear this from a lot of young people as well, Dan. I don't need a will because I'm in my early 20s. I don't have a lot of assets. If I pass away, somebody will fix it for me. I get like somebody's going to sort out my estate. But I think a lot of people don't realize that it is so, this document is so important. And if something happens to you and somebody you care about is in the hospital, you need to be able to provide the hospital with legal documentation to say that you have the right to make decisions about their care, sometimes end of life care, sometimes huge life-changing decisions. And what happens without that document if you can't provide it to the hospital? Dan?
Yeah, and if you don't have that document, it takes the control of what you would want away from you. And what you may want might differ slightly or significantly from those around you that are then tasked and forced to deal with this on your behalf. In the case, for example, of your elderly couple and one now has dementia, it really is, it not just adds many multiplications of the cost that could have been alleviated if they had a proper power of attorney done, but it also costs time. And dealing with the probate process after death, or even just dealing with having to apply to the courts and involve the office of the guardian and trustee, which is a provincial branch that helps deal with these types of circumstances. That's really costly in terms of time, and it takes a long time. So if he wants to turn around and sell the house, it's not happening for a while. And it's very difficult and costly, and it could have all been avoided for a very meager cost. In terms of your healthcare decisions, again, that power of attorney is very critical because it allows you to say, something's happened to me, this person's making the decisions, and what you want in terms of your input. It lets you give input while you still have capacity. And if you don't, then you don't have input anymore. And it makes it that much more difficult for people who are dealing with a very stressful and difficult time. They're having to either grieve over your loss, or in the case where you're incapacitated, they're having to help. They've been charged with the task of someone who has physical or mental challenges at that point in time, disabilities. And on top of all of that stress and their regular daily life stresses, it's going to add a whole bunch of cost and potentially times. The example, young people, okay, you don't have a lot of assets. If oftentimes I would say if you have no assets, then a will, it doesn't really make that much of a difference because no one's going to be applying for probate. As long as you do have some assets, then it really does make a difference. Or again, other external factors, minor children, things like that, where you really do want control after you pass away. But it's not just that control, like you said, Carol, it's that important factor of investing, whether it's you paying yourself or someone paying on your behalf because they're going to have to deal with it after the fact, investing to minimize that cost and time loss. So it almost becomes that much more important for people with meager estates to have a will done because the proportionate amount of that high cost after passing away is that much higher for them. If you have someone with an estate of $50,000, incurring a, let's call it, we'll just say $1,000 or $2,000 fee to do your wills and powers of attorney, that is significant. So say it's $2,000 on a $50,000 estate. That's, you know, that's a significant chunk, where if your estate is $1 million, that cost is proportionally a lot less. And if you die without a will, okay, so that 2,000 or that 1,000 goes to $10,000 now. So that 50,000 you thought was going to be left behind, it's only 40,000, where it could have been 48,000. So it really has, it's a little bit counterintuitive, but it's almost that much more important for people with meager estates to do this in advance, so that they can maximize the benefit for and proportionally maximize the benefit for their loved ones after they pass away.
And there's a question, Dan, and that's probably timely because you're talking about costs. What's the average cost for creating a basic personal will and power of attorney? We've talked a little bit about this already, because I think it's a question, assuming that you're going to use a lawyer for it. We've talked about why it's absolutely critical, in my opinion, to use a lawyer for it. Although there are ways to do it yourself. I've seen, unfortunately, in 20 years of real estate, how often people who try to create something, it just ends up quite literally thrown out by the courts. Can you speak to what the cost of having a basic power of attorney for a single person or for a couple might be?
Yeah, well, let's come back to that one, because I do have, we've got that covered, so we'll kind of come to that. But it is important because there's different
power of attorney. Before you move in, I want to address Carol Efford's question, which that asks if there's protections in place so the POA isn't invoked unless truly needed. Is there a medical certificate or something needed to invoke the power of attorney? So let's say, for example, you know, you've got somebody who has an adult child. They're getting on in years. The child is now questioning whether they have capacity to be able to decide whether perhaps they want to stay in their own home. As an example, when does a power of attorney be invoked, and when is it invoked, and how do you avoid, how can one avoid abuse of a power of attorney?
Yeah, so there's also another concept when we talk about powers of attorney of immediate and continuing powers of attorney. So and we see this a lot where someone is they've got a residence here and a residence in Europe. And they're leaving for 6 months, and they want someone here to be able to deal with all of their investments, sign checks, do everything for them. You can execute a power of attorney that starts today, and it's operating. And now that trustee or a trustee company, sometimes people will hire a company to do this for you, will immediately start to do things on your behalf as if they're you. To the concept of, you know, your personal care. It becomes operative when it says it becomes operative. So there's some legality to it, but also in the power of attorney itself, it's important to say when this becomes operative, because that can really make a difference. So do you want it to become operative when your doctor says you no longer have capacity? And that's generally kind of the language that we use, is your physician has said you don't have the ability to make decisions for your personal care. So now your personal care power of attorney is invoked. Or you can have it say, I want the office of the guardian and trustee to verify that I don't. I want a capacity assessment to be done and paid for, and this is how it will be paid for before it's invoked. Things like that. And keep in mind, the more complicated you make it, the more complicated and difficult it is to have it become operative. But to avoid someone saying, look, I have power of attorney and you've got to do what I say, even though you really still have capacity, generally speaking, that's, you know, your doctor is the one who says, no, this person still has capacity, so this power of attorney is no longer applicable. Yeah, or isn't applicable yet. Yeah. So generally, the simple answer is that the document itself can provide that information.
Got it. We're moving on to a hot topic, which is probate. And I will say, from all of our pre-submitted questions, a lot of questions about what is probate taxes, how to minimize or avoid probate taxes, question about first dealings. So let's talk about what probate is and how it impacts people, because a big topic of conversation for a lot of people.
Yeah, and we're only going to be able to scratch the surface because it is very complicated, and it's very nuanced. Every circumstance can be very different. So my initial answer to all of those questions that we may have is call a lawyer, call your accountant, because there's input from both of those professional services that are very critical to maximizing, minimizing probate fees, minimizing capital gains. That's a big hot issue nowadays with the capital gain room going up, the exemption room going up, sorry, and the capital gain tax itself going up. And a whole bunch of other kind of fees and taxes and how we can avoid them, and utilizing trusts in certain circumstances, and all of those kind of things. Gifts for property and all of that kind of stuff. So back to kind of simplifying, what is probate? At this point in the process, you've passed away. You either have a will or you don't have a will. We're going to kind of go ahead presuming you've got a will and you've taken care in advance to say, this is what I want done with my estate. Costs to go through a standard simple type of probate, you're looking $2,500 to $4,000 or $5,000 for kind of simple ones. Where you don't have a will, multiply that. The $4,000, 25 to 4,000, 5,000 becomes 10, 15,000 very quickly, because there's a whole bunch of other steps that have to go into it, not just at the application point with the court, but also just the lawyer having to work on your behalf, figuring things out, work with you, phone calls, meetings, all that extra time, that cost adds up. So being able to organize in advance minimizes that time cost down the road. What probate does, this term means you've passed away. Your estate trustee now goes to the court and says, this person has passed away. Here's a death certificate proving that they've passed away. And this is what I'm the person that should be tasked with dealing with the estate. And this is what I'm saying should happen. I'm saying it should happen because there's a will, or if there's not a will, I'm saying it should happen because these are the laws and this is how it should be applied. The court then says yes or no, and off you go in that respect. And after that, it allows you as the trustee to move ahead and start to deal with the estate. It's not always required. There are circumstances where you don't need to probate. If someone doesn't have any assets, you don't need to apply for probate because there's nothing to probate. There's no assets that we need to deal with. If you do and you have significant assets, then generally speaking, you have to. Generally, the estate trustee is appointed by the will, or if there's no will, someone can also apply to the court and say, I'm a trusted friend, I'm the next of kin, I'm the spouse, I'm the child, and I should be the one to make the decisions and why. And once you go forward with it, that's where the court says yes or no that you can deal with it and who can deal with it. In terms of probate, when we talk about estate taxes, which is more of an American term and concept, but here we call them probate fees, because no one likes to call anything a tax these days. It's approximately 1.5% on the assets that have to be probated. So what does that mean? You try to minimize and avoid the amount of assets that are in your estate for the purpose of probate. So that's where we get into the concept of secondary wills. That's where we get into the concept of gifts during life, inter vivos gifts, that kind of thing. And look at that. The next slide deals with that specifically. So how we start to deal with kind of the really shallow level in terms of minimizing the cost to your estate in terms of the estate administration tax, the probate fees. Different things. One, there are trusts that we can do. So it allows you to, trust law is very complicated, but there's certain times where you can dispose of an asset into a trust, and then that can be distributed out of the trust in accordance with the written terms of that trust. There's some advantages to that. There's some disadvantages, and one of the main disadvantages of doing things while you're alive, whether you're transferring or gifting property to children or loved ones or setting up trusts, is that you no longer technically own that property. So you're inherently in a trust, you're trusting someone to do what you want. And if they don't follow the rules, although they may get in trouble for that, and you may be able to sue them, or the beneficiaries may be able to sue them, you may already have lost the property or prejudiced that asset. So that can be a problem. There are certain circumstances in which you can give property or assets to people during your life, and that way you don't have to pay tax on it when you pass away. If you've got If I have a gold brick and it's worth $200,000 and I give that to you, Carol, when I pass away, that's not my asset, that's your asset. I don't have to pay probate fee on it. So we've avoided that tax. But again, you now have it, I don't have it. So if during my life, if I need $200,000 and I want to sell that brick, you've got it, and I don't have a right to it. And gifts can be very complicated as well, because there's rules about giving to people, whether a gift is automatically considered effective or whether you have to go further and have written documentation to that effect to allow the gift to be presumed to advance to that person. Other things that you can do, and this is a real big one and kind of a big takeaway for most people on the call, is to avoid probate fees on certain assets. You can just designate beneficiaries. These are only certain types of assets, but it allows you, for example, with a life insurance policy or an RRSP, to designate that the beneficiaries of your estate, and as you designate, will receive the outcome of that asset instead of it falling back into your estate, which then has to be probated. So, for example, if you have an RRSP and it's going to be worth $100,000, and you say, with your RRSP holder, you say, my beneficiaries are my 2 children, they're each going to get 50%. After you die, your 50% goes to them, no probate fee is paid. If you don't do that, that $100,000 comes into your estate, it becomes part of your estate for probate, and you have to pay tax on it at 1.5%. So you lose that little bit of extra before it gets divided amongst your beneficiaries. So if you can have it divided at source, you save that money with that designation. Another way is where you have properties owned jointly. Joint ownership of certain assets automatically devolves to the other joint owner, who is the survivor. So, for example, spouses who own a house together, if on title it shows them as joint owners, one passes away, automatically that person's interest in the house goes fully to the other person. So you now don't have to pay probate on it. That other person has that property and owns it clear. Joint bank accounts is another example, and a lot of people will do that. They'll add their children to their joint bank account so that when they pass away, the $40,000 in there just goes to their children. It
Great.
gets more complicated. Yeah, so you're about to ask a question about how do I transfer property to my children while I'm alive? I know that's the question you're going to ask.
It actually wasn't. It was about tenants in common versus joint tenancy, because I've got a couple of questions about investment properties, and I want to be clear, just because you are both on title does not mean that you have joint tenancy. And perhaps you can speak to that, because there are some circumstances where when you pass away, it passes to the other owner on title. And in other cases, when you pass away, your interest in that property stays with your estate and gets divided up as per your estate. So if you own, say, an investment property or cottage with somebody else, maybe you can speak very high level to that, Dan, to the necessity of people understanding how they hold title to something, because it's different, right?
Yeah, and you should. One way to know if you're getting good advice when you do a real estate transaction is someone asks you that question if you're buying with multiple people, because that's a really critical component of acquiring real estate when there's multiple owners. So, for example, spouses, you're married, you've been married forever, you're going to stay married forever, presumably, and despite the odds these days. If you own a property as joint tenants, the term joint tenants versus tenants in common, joint tenants means if I pass away, my share goes to my joint owner. So automatically, if Bill and Ted have gone on this excellent adventure together to buy a property, and they each have put in $200,000, and Bill dies, and they own it as joint tenants, automatically Bill's share comes to Ted, even though Bill had in his mind, he thought, I'm going to leave it to my children or to other people. Ted owns it now. It's Ted's asset. So there are some exceptions to these kind of things, but that's how a joint tenancy works: is your asset goes to the other person.
And I think this is really important.
A tenancy.
Yeah, I wanted to say this becomes really relevant because I've got a bunch of questions here about leaving cottages to children, and we will have clients that either pass them before death or after death, and their intention is, of course, that it stays in the family. I hear this a lot. These are legacy properties. Sometimes they've been owned by decades, and their intention, or I guess their intentions will vary, but sometimes you'll be in a situation where, say, you've got 3 kids, title passes to them. But depending on how you set it up, it could play out 2 ways. So title passes to your 3 kids. When one of your children passes away, then the 2 remaining children end up with that asset. The second passes away, and then the 3rd child and any heirs to them end up with the entire asset. Some people will set it up so that, you've got 3 kids, and when one of those kids passes away, it's the grandchildren that inherit their share, and then you get fractional ownership. So I see this happen a lot with real estate transactions involving cottages. And I will say, proceed with caution if it is your intention to transfer title to your children. You really, really need the advice of not only a lawyer, but some tax planning there to make sure that your intentions are being understood, and also that you don't create a huge tax liability for your kids as well too. I see this a lot with transfers of cottage properties.
Yeah, let's park that for just a second, because there are legal, tax, accounting, and just practical, wisdom, experience, having seen it many times, what to be looking out for in that circumstance. Just to finish the tenants in common and joint tenants concept, tenants in common is the other side of that coin, the flip, where Bill and Ted own the property together, and Bill passes away, but they own it as tenants in common. His share doesn't automatically go to Ted. It goes to his estate, and it is divided either amongst his beneficiaries in accordance with his will, or it's divided, if he doesn't have a will, in accordance with intestacy laws. So generally speaking, to his next of kin, and up and out through the we call them lines of consanguinity, but out to your closest next of kin. Back to the cottage type of question. Yeah, sorry, go ahead.
I was going to just ask about next of kin, because people will often assume I'm in a common law relationship, that next of kin is going to be the person that I am in a common law relationship, or my next of kin is going to be my adult child, or my next of kin is going to be fill in the blank. Maybe you can speak to that, because it's often remarkable to me when I've seen that chart about how next of kin is determined. It's a really interesting thing to see. And if you work with Dan, you can ask him to see it. I'm sure he's got a copy of it. How is next of kin determined? Because you would think that it's going to be the person, quote unquote, closest to you, but that in fact is not there. What is the threshold for that? How is next of kin determined if you don't set out your wishes ahead of time?
Yeah, so that chart that you're kind of referring to is me, my children, my grandchildren, my spouse, my parents, my siblings, and then my parents' siblings and their children and their grandchildren, and it kind of does the big family tree web. And so who's closest in what direction. But that chart also, which you don't usually see, has little asterisks all over the place, because there's family law, there's all sorts of different nuances to the law that create exceptions to all of it. So it becomes it's a big web, and then it's all filled with red, where it's like, scratch, except for this case, this. So it can be very, very difficult. Generally, you think about my next of kin is my spouse. So, or I guess you're born, your next of kin is your parents, because you don't have a spouse, you don't have children, it's your parents. And if your parents have passed away, okay, it goes out from your parents down to your siblings. Well, now you grow up and you get married. So your next of kin becomes, in law, your spouse. Wills and estates help you kind of determine and create control over these things. But then you add some children below that. Okay, your spouse passes away, your next of kin are your children. Your children pass away and your spouse passes away, back up to your parents and out like that. It can become really complicated. It especially becomes complicated when your spouse is no longer your spouse. You separate or you divorce. And that creates its own potential hurdles there, because you may be still married to someone, but you have a common law partner. Your common law partner isn't necessarily your next of kin. in law. So then, that's where your powers of attorney and your will can come in, and separation agreements and official divorces to have a divorce certificate all become very important with separated spouses. With separated spouses, it's a really complicated area. If you have a separated spouse where you don't have a separation agreement, or your separation agreement, you did it yourselves, newsflash, it's probably not worth the paper it's written on. Like very, very likely not worth the paper it's written on if you didn't use lawyers. And even if you did use lawyers, you better have good ones. And then secondarily, a divorce order is very, very critical there as well. So if you have an estranged spouse that you're not divorced from yet, speak to a lawyer when you're starting to do your estate planning, because it's very critical, and it's really complicated law and fraught with a lot of challenges.
If you question this at all, Dan, you just need to watch the whole first season of Downton Abbey. It basically, the laws of succession and how next of kin is determined just takes up the entire 12 complete episodes of determining how an estate gets passed to somebody that nobody has ever met or heard of before. But in fact, it does happen. You get into a situation where it ends up your estate assets without proper direction can end up with second cousins and stuff. So I've seen it firsthand, unfortunately, get really complicated. Okay, so ways to minimize administration tax. I think we've addressed a lot of that already. There is a question about whether or not, so you have a parent's house that a parent that passes away, are all properties subject to probate? And there is terminology that hopefully you can share about this. You've got parents that have lived in the house since 1965. Are all real estate sales subject to probate?
So let's come back to that one, because we've got the question of the cottages as well. Let's kind of hit some of those at the end, and I'll just power through here. That way we can just finish off the last bit, because there's some nuance and specific to those that I'd like to get into. One of the questions that we had discussed beforehand, and I know is one of the questions, is how do I prepare a will? What do I do? You can do it yourself. If you do it yourself, fraught with potential issues. Again, you have to make sure that it meets the formality rules. It's accurate, it's witnessed, all the different things that have to be done. And if you pull something online, you might not be dealing with Ontario law. And even if you are, it might not be good enough, which we see all the time. And if you get someone to help you prepare one, an accountant, for example, I've seen accountant prepared wills where we throw them out, and after the person's passed away, it's no good, didn't help. So make sure that you have a knowledgeable person, generally a lawyer, in the industry who can help you. It doesn't cost that much. We'll come back to costs though. But again, for doing wills, you're in the $1,000 to $2,000. Depends on the complexity. It can be much more if it's very complex, but that's around the cost. If you do it yourself, the costs can be astronomical, because again, you might create a whole bunch of problems, and not just the cost to do it, but the loss in terms of not planning effectively and having that advice where a knowledgeable professional can say, but did you think about doing it this way? Because you'll save a whole bunch of money. Options: retain a lawyer. It's a little bit more expensive. It's not a significant cost though. It's much safer. Do it yourself. There's online templates, generators, things like that. Some of the issues that can arise there is, if there's mistakes, it's much more expensive. You don't have the full knowledge of how to properly maximize your estate planning necessarily, and what you see online might not be applicable. And from a lot of the questions that we saw in advance, a lot of the information coming at you, TikTok, Facebook, Instagram, online, Google, yada, yada, it's not all applicable. And it could really add up in terms of stress and cost to your loved ones, where they could be, after you pass away, grieving and celebrating your life, and now they're running around trying to deal with these issues that you've left behind. So this comes kind of back to, so again, wills let you control what happens to your estate, minimize the burden on your loved ones. When we talk about costs, Our standard costs, for example, at our office, which are pretty market in the industry, it's about $1,000 for a will to be done for an individual. And that includes your powers of attorney. And then we also generally will allow clients, if they want, the option to store their will with us. It's a one-time fee of $150, and that just pays for us to residence your will in a fireproof, waterproof safe. Couples, we do a little bit of a discount. It's $1,500 for a couple. So that's generally our cost, and that's kind of for the very simple version. A little bit more complex, the costs can be more complex. As part of today's program, Carol, as we discussed and you alluded to earlier, we're gonna give away one, lucky winner is gonna win a prize of a will package. So we're gonna be doing that, but also it can be very difficult and stressful, and especially nowadays. Everyone in every industry and walk of life is feeling the crunch financially these days, and it can be very difficult to say, you know what, I just saw this presentation, I gotta do my will, but I don't have $1,000. I don't have So one thing that we are offering, and this is a little partnership with you, Carol, is we're trying to help get this. So if you're on the line today, or you're watching this after the fact, for this summer up until the end of August, our office is going to be we're willing to do wills for clients, and so we've provided a little discount code here. You'll see Foderick 2024, and that allows you to contact our office, and if we get you in process by the end of August, then we can get you a will done, and we're doing that for $500 for an individual, or $750 for a couple. So it's half the price of what would normally be the cost, but certainly allows you to invest in yourself and your loved ones. And as part of that, we'll also store the wills for you for free. So that covers that cost, and then now we can kind of come back. Why don't we come back to questions and answers? I'm going to stop sharing. I'll also, though, I will add, and I'll go back. Carol's office and our office work closely together in many ways, and we're not just friends personally, but also professionally. And so one of the things that we do for Carol's clients is we offer a little bit of a discount for her clients as well. So from a real estate perspective, if you're buying or selling or refinancing your mortgage, let us know that you came in through Carol's team, and we apply a little bit of a discount on your fees there as well. So every little bit helps, and that's something that's available on a go forward, though, that we continue to offer.
Thank you, Dan. That's so appreciated. Just so you know, guys, full disclosure, I don't receive any sort of remuneration or kickbacks from Dan. The reason why I try to put intelligent professionals in front of you guys is just so that you're getting the access to the best service providers possible. So there is no benefit to us if you work with Dan, but I want to be clear, he is a skilled professional, and he's helped many of our clients. So hopefully you'll use him as a resource. Okay, so a couple of questions I want to come back to. Whether or not all real estate transactions are going to be subject to probate. So your mom or your dad dies, you have a house to sell, they've been in that house for a really long time. There are some circumstances where probate is not applicable. Can you speak to that, Dan? How to figure out whether or not that's the case or not?
Yeah, I mean, the best way is, at that point, contact a lawyer. You can do a probate on your own. It is quite complicated. It's stressful. You've got to do proper filings. It takes a long amount of time. All of that stuff, which lawyers are really, at this point in time, really effective and cost effectively able to assist and give you some advice. Things to consider in that kind of case is, they own a house, for example. Does it have to be probated? Generally speaking, real estate falls under the rule that it has to be probated. There are some exceptions for probate. Again, if we have a secondary will, we can have corporate assets. If you have a property that's been owned long enough that, for example, it was owned under the old, this becomes more complicated property law, under the old registry system. So if they've owned it since the 90s, then you kind of get into that concept of, oh, we might be able to avoid probate on this asset. So that's really kind of generally we think about, okay, you're thinking about probate. have you owned the property for a long time, or do you have a corporation? Those are kind of the two main exceptions to the probate rule.
Yeah, it's the owned the property for a long time. People are often surprised to hear that there are exceptions where if their parents are, original owners of their, their Pickering bungalow and it was built in 1965, that there are some circumstances where probate is not applicable. So first steps, I think, because you've obviously given us a lot of information, if there's somebody that is interested in moving forward with getting a will or power of attorney done, obviously we're going to provide your contact information. It'll be in the link that's included when we share this. You can reach out to Dan's office this way. But what documents do you need? Where do you start? What should you come to that meeting equipped with? Should you figure out ahead of time, kind of where you want everything to go, or should you sit down with a lawyer and talk it out that way?
Yeah, I mean, the first step is take a step. That's always my suggestion on everything is, and I think it might have come from Marcus Aurelius, but just starting is the first step you take is the most important step. Call our office, send us an email. Our staff will get you set up with a conference so that we can get the ball rolling. The first thing that you're going to need anytime you talk to a lawyer, especially nowadays, you're going to need your ID. We have to verify who you are. That's really critical so that we can verify and avoid potential fraudulent situations. And lawyers and various professional service providers have an obligation to make sure that we know who we're dealing with so that we're avoiding fraud into the marketplace. It's kind of a general obligation that we have. First thing to do, though, is have another concept. The first concept is have those conversations. They can be very difficult conversations. Either have them in your own mind or have them with loved ones and trusted ones. Because after you pass away, you're not going to be there to speak your mind and provide an opinion. So that's what your will is going to be there. It's there to speak for you. But you're also still alive. You can speak for yourself. You can have those conversations. You can ask questions. Hey, ask your friends. Hey, do you guys have wills? Who did you use as a lawyer? And were they good? Did you like them? Did they charge you too much? Did they say it was going to be this amount and it ended up being this amount? Do you really believe what they said? What did they tell you? So those are questions that you can ask to make sure that you find the right person that you trust and that you trust will have your best interest in heart and really care to do a good job and give you fulsome, proper advice. But really the first step is just start to turn your mind to it and reach out. And that's our job too. Part of the lawyer's job is to ask you questions, to think about things that you might not even know are relevant questions. For example, like you spoke about, Carol. All right, well, I've actually owned my house since 1975. Well, your house might qualify for the exemption from probate under, we call it the first dealings exemption. So that's something that you might not even just be thinking about. So when you talk to a professional, it's important that they ask you questions about your assets so that you can really determine whether or not there are avenues for maximizing both the financial aspect of things, but also just the stress and complexity of things that you leave behind.
And so a question for you on that. People are often, I think, misinformed about who you can name as a executor or as your power of attorney. Does it always have to be your next of kin? If your next of kin is not somebody that you would trust to make those decisions, or you feel is not, capable, is there an alternative that you can suggest? Perhaps the lawyer themselves. Maybe you can walk through that, because in our dealings with estates, it's quite common that the beneficiaries, even though they are next of kin, are in fact not named as estate executors. Parents will make a decision if there's 3 or 4 kids that they're going to name a completely independent third party so that there's no fighting between, the kids over what happens to the house, or they will give specific directives in their will about what happens, but over something that could be a very highly contentious family asset. So that there's no concern about that. Can you just speak to other alternatives to next of kin for naming that person?
Yeah, so your will names your executor, and that executor, the term is synonymous, executor trustee. And when you think about a trustee, you see the root part there, trust. Who do you trust? Who do you trust to do a good job, to be knowledgeable, to be able to handle the issue? Your beneficiaries, if they're your children, they may not you may not want to leave them with the emotional burden of having to do all of these things, the time burden. If you've got one child and your daughter has is a single mom with a young baby, like, and she's working, dealing with your estate and applying to court, that could all be just way too much. But you've got a friend or a parent or a sibling that can handle it, and then that may be a better choice. And it really comes down to, who do you trust to be able to carry out your wishes that you leave behind, and making sure that those wishes are clear to that person. Oftentimes we do see, like you said, you may have several children, and you don't want to leave them, or any particular one of them, to be the executor, because it can create a conflict between them, and it might just be that much easier for them and for everyone involved to have someone that you trust, that's an independent other party. Some people, as well, as even if and this is quite common for very complicated estates, or people who don't have near to them next of kin, or friends or family that they believe would be appropriate to handle those duties. There are companies that you can hire that can do that. So you can work with your lawyer to identify a trust company that can do that, and their offer as a professional service. And some of the banks will do that as part of their offerings to clients, is for a fee. They're able to provide those services, and sometimes that can be a lot more cost effective and time and stress effective than leaving a personal executive as well. And it may be, maybe you speak to your lawyer who does the estate administration for you, and say, you drafted my will, I want you to be the one who does the probate for me, because you're independent and you have been given my instructions, and I know that I can and trust you to do a quick, efficient job of that. And you could end up in a scenario like I am, where I'm a lawyer and have knowledge in this area, and I end up getting the bulk of burden from friends and family, and God knows how many of these I'm going to have to do personally, not just professionally, in the future. And we do. I also have some clients who have named named myself as their estate trustee, or as an alternative, so that they know that someone knowledgeable will be there to deal with it, and it doesn't have to rely on their children or spouse to handle their estate matters after they pass away. And there is another concept too to keep in mind, is, yes, you can hire someone, a lawyer, a trust company to administer your probate and estate after you pass away. But your estate trustee or executor, they're also in most circumstances able and willing to draw a fee as well for the time and services that they provide in administering your estate. So that's a concept to speak to your lawyer about when you're drafting your will. How much are they entitled to, and do they want to be paid? Do you want to pay them? All that kind of stuff.
A question for you, Dan, because you've been doing this a long time. How do you go about making a good decision about who should be the executor of your will? So I'll give you an example. People will often choose, next of kin, spouses, adult children. But say you've got a number of adult children. What's the skill set that you might look for in your children or in your friend group for who makes good executors? And I'll give you a personal example. My husband's the named executor for my mother-in-law's estate, but he's the co-executor with my sister-in-law, who may or may not be on this call. I don't know. Carol Winter, if you're here, I love you, but this is going to be a train wreck. We all acknowledge this. And it's because you have different personalities who are going to be tasked with doing something during a very emotional time. And the challenge, I think, is going to be, my husband's going to try and order a bin and dump all of the belongings into it a week after my mother-in-law passes. And my sister-in-law, bless her heart, is going to want to go through every single photo album over the course of a year and make sure that, everything is saved or given to a grandkid. Very different perspectives. And it's been my experience as a real estate professional that one is not right and one is not wrong. A lot has to do with the way that people grieve differently. So Dan, what can you give in the way of a recommendation for how somebody goes about smartly choosing from a group of highly capable individuals in terms of making this go as smoothly as possible while their wishes are also respected? Because I'm sure it's not just a lot.
Yeah, I mean, that's really, it comes to doing a will allows you to have that control. It allows you to speak after the document speaks for you after you've passed away, saying who I want and what I want them to do and how I want them to do it. But while you're alive, when you have to turn your mind to, okay, who is that person that I want to insert there? Again, that kind of comes to you. Who do I have in my circle that I trust that is going to be able to carry this out, both from an emotional and stress perspective, but also from a knowledge and capability perspective, timing. Do they not have time because they're busy working, or their profession keeps them from, from being able to deal with? Do they live, maybe it's my child that I would want to be my estate trustee, but he lives in Australia. And my assets are all here. He's going to have to fly back here, or it's going to be a real rigmarole for him to deal with it, or her. So there are a myriad of different factors in your life, but part of helping you make that decision is ask your lawyer, ask your professional service provider. Hey, I'm thinking about my 3 kids. Should I do my 3 kids? One of them is, in jail right now for stealing from me, and the other 2 are always fighting with each other and don't talk. Well, you got a lot of red flags there to have all 3 working together. Maybe it's using your best friend or cousin who is a lawyer or an accountant, or just generally is reliable from kind of an organization perspective. But you want someone who is emotionally going to be able to deal with things. Financially and time, they're going to be able to deal with things, and that you trust. Those are the biggest things to keep in mind. And you don't want to, while you're getting to control what happens after you pass away, control it. Don't just say, I'll leave all my children, or I'll leave all my cousins, or siblings. Really think about it, and it gives you that opportunity to have that control.
Thank you, Dan. I want to just touch really quick in our last few minutes about cottage properties, because this is one I get asked a lot about, and it's the ones that I see often being the most contentious, because often there is a strategy there for some tax minimization, and it leads people to try and transact properties either before they've passed away to adult kids who are hopefully all going to share it, in harmony. But we see this turn into a highly contentious issue more often than not. Can you maybe speak a little bit to best practices if you are the owner of a cottage property, you have adult kids, you would like to keep that cottage property in the family, how best to handle that? And I know that involves a whole bunch of other professionals as well, including getting a good understanding of the tax implications to a transfer. But in terms of best practices for dealing with cottage properties and succession planning there, how do you best handle that, Dan?
Yeah, so we get a lot of questions, and we see a lot of things where people really focus and fixate on, I want to avoid my probate fees. Probate fees, generally speaking, about 1.5%. Now, this isn't the concept of capital gains and land transfer tax and other things, but just probate fees, it's not that much, because if we're talking about $100 asset, it's $1.50 of that goes to tax. So how complicated do you want to make things, and how much risk do you want to create by putting trusts in place and transferring property that you own and are going to rely on during your life to other people, those kind of things, just for that small little benefit of 1.5% that you're avoiding? Oftentimes people get way too complicated in their mind to avoid something that's really little. And they could come up with these strategies that fiscally actually cost more, especially when you talk about the time value of money and different actuarial principles and what you can do with investing and all of these kind of things. Specific to, for example, cottage properties or vacation properties, that kind of things. Cottage is a really common one here in Ontario. So one of the things that we'll hear is, well, can I put it in a trust? One thing to know, and you do see there's a common TikTok video. I don't have TikTok, but it's been forwarded to me. And many real estate agents that we work with have asked me the same question about the same video. Trusts in Canada are, generally speaking, in Ontario, are for, there's a mechanism for trusts when we talk about the finances, is for capital gain avoidance and spreading out a capital gain exemption room over multiple people for qualified small businesses. Doesn't really apply in the context of properties. Properties can't be owned by trusts in Ontario. They've got to be owned by individuals or corporations. So keep in mind when you're seeing these things online, if you're seeing things like that, hey, there's this complicated trust scheme that's in the US likely, and things you see online, ask a professional. When it comes to cottages in particular, we get a lot of questions of, well, what if I gift the property to my children now, and then I can avoid the probate fees? Okay, so if you gift a property and say we're not talking about, if we're talking about the principal residence, you own your principal residence, you gift it to your children. Okay, or you add a joint tenant. There are things that we can do that potentially minimize or avoid probate fees, but you can create a scenario where you then create this huge later tax burden because that property isn't your child's. If say it's your principal residence, it's not your child's principal residence. So if they then go to dispose of it later, there's a massive capital gain that would be applicable. And so instead of avoiding 5% tax, they have to pay this huge amount of tax, which, as most of us know, if you've been paying attention to the news, the capital gain tax in Canada has just gone from this amount to this amount. So it's about capital gains are on 2/3, taxes on 2/3 of your capital gain now instead of half approximately. So that capital gain can be really significant. The concept that we hear about often with, well, I have a cottage, why don't I put that in my children's name, and we'll avoid some probate fees. The problem that you create there is you can create a deemed transfer where you can get into a situation where, maybe we can avoid some land transfer tax on the conveyance because it's a gift, but you can create a scenario where you can create significant capital gains issues. Maybe you avoid a little bit of probate tax, but you now don't own the property. So now you don't control it. Those people control it. And I have seen examples where parents and children get along really well, and assets are transferred to the children years later. They're not getting along well. And the parents are out of luck because they gave that property away. You don't have it anymore. And in the case of cottages, for example, you don't have it anymore. You don't have a right to go there. It's not your property, so you can be told to stay away. You can't sell it and profit off of it if you need the money for your own care, those kind of things. But that capital gain situation comes up. That's where you have to talk to a lawyer and an accountant, because a lot of those kind of I'm being creative solutions have worse implications when you step them down, and especially that's the case with cottages or properties that aren't the principal residence. Is it really can trigger higher capital gain and other costs, including you can create a scenario where you have a double tax cost on some of those assets, and that's a little bit too complicated for today's purposes. But before you do that kind of thing, talk to a lawyer, not just a real estate lawyer. Don't just call the cheapest real estate lawyer around so you can do something you heard about online or your friend told you about. Talk to a knowledgeable lawyer and have a sit down with them. It's worth paying a little bit of money before you go and dispose of assets or do something that could cost you a lot more.
Final question, Dan, as we wrap up today, I've got a question. I'm currently the executor for a family member. They also noted in their will another executor, my sister, could be a backup. If they pass away, but I can't act as their executor due to an unforeseen circumstance, what is the process for appointing the backup executor? Is it complicated? So if you're the first person and you can't do it for whatever reason, or you choose not to do it, can you opt out of it even though you've been named? And does it make it much more complicated?
Yeah, so you, in a will, as being named as a trustee, you can't be forced to do it. So that's the first thing to know is if I do a will and I have two sisters, and I leave my sister Rebecca, who's also a lawyer. She's a younger sister, and I told her not to be, but she still decided she'd be a lawyer, and she's a great one. But I tried to coach her out of it. So say I leave her as my estate trustee, and then I leave my other sister as the backup if Rebecca predeceases me or doesn't want to or is incapable of doing it. So you do have a right, as if you're left as the primary trustee, to not do it. Say, you know what, I don't want to do it. And then the alternative would come into play. When it comes to being the estate trustee, you don't, even if you're named as the first named, you don't just become the estate trustee. That's where you have to apply to the court for probate, and you say, I'm asking you to name me as the executor so that I can start doing things for the estate. So the first step in applying for probate is you ask the court for, we call it a certificate of estate trustee, so a certificate of appointment, where the court appoints and verifies you, Sandra, are going to be the estate trustee for this estate. To do that, Sandra has to take the will and say to the court, or there's no will and says, I'm the next of kin, or I should be because of this, this, and this. And she goes to the court and provides documents and application that says, please verify that I can be the estate trustee. The important component of getting that step done is when that certificate comes back, is now you can act as if that person who's passed away, you're their voice, and you can act for them in their afterlife, basically. So you can sign contracts, you can pay taxes for them, you can transfer property if they own a house, which you can't do until you get that certificate. If I'm named as the first estate administrator, the first trustee, and I don't want to, I don't have time, I'm sick, I've died, then I just don't do it. And then the next person named, they're the one who makes the application and says, I'm named as number 2, I'm the alternative, number 1 doesn't want to do it. So, and generally to help that, we would do a document where we have number 1 sign off saying, yeah, I don't want to do it. Or number 1's dead, they're not around, they can't do it, that kind of stuff. And then the court says, okay, great, that person's not available, around, they don't want to do it, so we'll make you the appointed estate trustee. So that's kind of the process for that.
Thank you so much for that, Dan. As promised, we're going to draw now for somebody to receive the services of Dan and his law firm this summer to be able to receive a wills and estate package. If you are interested in entering this, I'll just ask you to use your function to raise your hand, and we're going to leave them up for a moment. And then Dave, who is our marketing person who is monitoring this ahead of time, will be just choosing somebody at random. So if you can raise your hand, that would be amazing. I see a bunch of people raising your hand. I'll give you a few minutes. And I just wanted to say thank you, Dan, for taking the time to sit with us today. I know that there was a lot of questions. Some of them were a little bit more complex and probably warrant a call directly with you or with a trusted legal professional. So if your question wasn't answered today, it was because it was probably a little bit too specific to be relevant to everybody else on this call. But there were some really great questions, and I think we've addressed probably 80 or 90% of them.
I can add, there was one that was sent to me as well that maybe this is helpful as well. Someone had asked, I'm 99% sure of what I want to put in my will. You know, what should I do? Should I go ahead and do it, or should I wait till I'm 100% sure? Well, like kind of to add to what we discussed before, the best first step is taking a step. Call a lawyer so that we can ask you those questions. We can do things and get the ball rolling and have you help you think about things from different perspectives so that you can make those decisions. The concept of I'm 99% sure of what I want in my will, 99% sure of what you want in a will is 0% of a will, right? So unless you have a will, you have zero will. So that concept of, you know, 99% is a heck of a lot better than 0. And so if you're 99% sure and there's some little tweak that you're not really sure, get it done. And then we can change it later. We can do a codicil or we can redo it, but get it done, because if you don't get it done, you get 0% input and control after you pass away, and you have 0% ability to control things from a financial perspective or an emotional and stress perspective.
Got it. Okay, so last chance, guys. I've got 15 attendees with their hand up for the giveaway. I just want to be sure that everybody gets a chance. And so put up your hands, just 16. I'll give you just a second more. And then Dave is going to choose somebody at random. We're going to just take some screenshots of who has, we've got 18. I'll give you just a minute more. And then Dave will take a screenshot and choose somebody at random. And just to protect everybody's privacy, he's going to reach out to that person directly to let them know that they've won So thank you everybody for attending today. I'm very grateful that you would choose to spend your afternoon with us. Again, you're going to be receiving a recording of this after the fact, and it'll also include information on how to get in touch with Dan and his office, as well as the pricing information and the discount codes that he shared. So thank you, Dan. I'm really grateful that you'd extend those to our clients. So thank you guys very much for watching. Stay tuned. Our next seminar will be coming up in September, and we don't have the subject matter finalized yet. It's either going to be secondary structures, which is another popular one, laneway suites and garden suites, or it's going to be a build renovation seminar. So to be determined. If you have questions about the real estate market, and my goodness, there is so much to unpack with what's going on right now, please reach out to the agent that invited you here today. They will be in touch with you in the next 24 hours. And as always, guys, it is such an honor to be of service to you. Hopefully you took value today. I know I did, Dan. Thank you so much. And we will be in touch with you again soon, guys. In the meantime, please reach out if there's anything we can do. Thank you, guys.
Thanks for having me, Carol.
Thank you.